Who's on phone number ending in 6047? Hello?
Hello,
What's your name?
my name is Rahim Ali Khail.
Okay. You need to dial in with the video.
I don't have any Zoom to video, but because
Excuse
I
me?
don't have Zoom to be in the video.
Oh, okay. Well, then you can appear in person. We're all in here waiting for you.
So I cannot participate without Zoom.
Yeah, we're not doing telephone calls. This is court. You gotta appear in person, or if you can't appear with the video, you get to come in person. Those are your options. Zoom is not
Okay.
a right that you have, okay?
Can I come there right now? I think I can make it like 10 minutes over there.
Absolutely. Come on down. We're here.
Okay, thank you. What room? What courtroom? 3 or 4?
This is courtroom 4.
Okay, thank you, ma'am.
Thank you. You too. Okay. On the record, in the matter of the people of the city of Lansing versus Andrew Parales Jr., file number 21-02385, council appearance.
Good afternoon, Your Honor. City of Lansing appears by Greg Venker.
Assistant Public Defender John Lee on behalf of Andrew Parales.
Mr. Parales, can you hear me?
Yes, I can. Good morning, Your Honor.
Good afternoon, sir. Today was the date that we reset this matter for a pretrial and driving while license is suspended. How are we proceeding on this?
Your Honor, Mr. Parales would like to accept the previous offer made by the city attorney to plead to failure to display a valid license.
Is that correct, Mr. Parales?
Yes, it is, Your Honor.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I do, Your Honor.
Okay, you can put your hand down. Mr. Parales, you have the right to proceed to a trial, and you have the right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, Your Honor.
You have the right to require the city to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt at your trial. You have the right to remain silent at your trial and not have silence be used against you. You have the right to confront and cross-examine in court any other witnesses the city intends to call against you, and you have the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. Are you willing to give up all of those rights today?
Yes, I am, Your Honor.
Anybody threatening you to get you to waive those rights?
No, Your Honor.
Has there been any promises made to you in exchange for a waiver of those rights?
No, Your Honor.
As to the amended charge of failure to display a valid license, how do you plead?
Guilty, Your Honor.
Factual basis.
Thank you, Your Honor. Mr. Parales, on or about August 24th, 2021, were you driving in the area of West Hodge Avenue and Palmer Street?
Yes, I was, sir.
And that's in the city of Lansing, County of Ingham, correct?
Yes, sir.
At that time, you encountered a police officer, you were pulled over?
Yes, I was, Your Honor. I mean, sir. Yes, I was, sir.
And the officer asked you for your driver license and you failed to display or provide a driver license at that time. Is that correct?
Yes, sir.
No further questions, Your Honor.
Any questions from the city?
No, thank you.
The court is satisfied with the factual basis. I'll accept your plea and find it to be freely, voluntarily, and intelligently made. You get credit time served. You're all set.
Thank you, Ms. Simmons. Appreciate your honor.
Thank you. Have a good one.
Thank you.
On the record in the matter of the people of the city of Lansing versus William Oster, file number 24-0086 and 24L2828821. Council appearance.
Sorry, good afternoon. City of Lansing appears by Greg Venker.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of William Oster.
Okay, today's the date that was set for a pre-trial. I have a driving while license was not valid or improper, and then I have a informal hearing explanation hearing for speeding 1 to 5. Was there an offer, Mr. Venker?
Yes. Hold on. Wait a minute. Well, an offer was extended. John, are you trying to resolve today?
No, my understanding of the offer was that if Mr. Oster was able to get his driver license, that the city attorney would amend the charge to a civil infraction of impeded traffic.
That's correct.
If he gets his license?
Yes, he is in the process of working towards getting his license reinstated. He owes 54A District Court for a no proof of insurance ticket and wants to pay that off and get his license reinstated.
How much time does he need to do that?
No more than 6 months.
6 months?
To get the license, back, I can get that today. I can get to the Secretary of State today.
Big issue.
Oh, $50 today, and then $50 for
How
next
much
week.
does he owe on the ticket?
How much do you?
I owe a lot of money. I'm not sure which one.
Your Honor, some of the details are unclear. The city attorney actually helped me to figure out what he was in arrears for.
Okay, you have a no proof of insurance that you owe $264. You have a no proof of registration, you owe $186.
I think the registration doesn't sit as a hold against him in Secretary of State.
No, I can.
Are you working?
Yes, ma'am. I just got a new job, so my paychecks are kind of rocky. I'm trying to get my hours straight.
Okay, I get it. Okay, where are you working?
Home Depot, Your Honor.
Okay, and so you gotta make payments and you're gonna make the first payment on that one when?
I can have that today, Your Honor,
The first payment on that today. When are you gonna expect to have that paid off?
as soon as possible. All my money's going towards it. So,
Yeah, I just need to know a date.
3 months from now, or 2.
3 months. They're not paying you well at Home Depot?
Trying to get as much hours as I can. She's
Are you full-time or part-time?
part-time. I'm
You're
trying to get
part-time.
full-time, but I'm only getting about 16. I'm trying to get more.
Can you put the ROA on that, please? No worries. I don't like doing math either. I got a calculator. Okay, so the matter that's suspending your license. You're gonna pay $50 today.
Yeah, yes, Your Honor.
Okay, you have. $25 penalty, $20 penalty, $44 late fee. Okay, how about this? I'm gonna give you a court date that you're gonna return to court for. You're gonna pay $50 today. You're gonna pay another $50. How often are you getting paid?
Twice a week, Your Honor.
You're getting paid twice a week? A month?
Twice a month. I'm sorry.
Okay, you're gonna pay another $50 the next month. I'm gonna give you a court date at the end of next month. That gives you an opportunity to pay that next $50. When you pay that, I'm going to waive $114 of fines attached to this as penalties, okay? That, once that's lifted, that will send a notice to Secretary of State to remove that suspension that they have on there so that they can reinstate it, okay?
Yes, Your Honor.
And then you'll be able to go and get your license after that, okay?
Yes, Your Honor.
March 25th at 9:30. March 25th at 9:30 is gonna be your next court date. Can you pull this file so I can write a note on it? You have any questions today?
No, Your Honor.
Any additional matters for the record?
Nothing for the defense, Your Honor.
Mr. Banker?
No further questions. Thank you.
Thank you. We'll see you March 25th, okay?
Thank you.
We'll get you a notice to appear. Sir, we're gonna get you a notice to appear. No, you're fine. You can have a seat. We'll get it for you. Okay, on the record in the matter of the people of the city of Lansing versus Telicia Nicole Brooks, file number 21L264421, 21L27013, so 232, council appearance.
Good afternoon, Your Honor. City of Lansing appears by Greg Bunker.
Assistant Public Defender John Lee, on behalf of Telicia Nicole Brooks, who's in the courtroom and standing to my right.
How are you, Ms. Brooks?
Good, Your Honor. How are you?
I'm well, thank you. Oh, we have one file, is that an error? I have to tell you to display ops, I don't have the expired license. No. Okay, today was the date that was set for a pretrial and failure to display operator's license and an expired license, which would have been a separate ticket. Is there an offer on these?
Yes, actually, the city is moving to dismiss both. You'll note that these are 2021 files. Both of them, they're within a couple months of each other. Shortly after the second incident, Ms. Brooks got a license and has held a valid license and driven legally since then.
Okay, so the court will dismiss both matters. You're all set.
Thank you.
Thank you.
I think I have a question. I'm about to get a job. Do I get the clearance today or do I? For the warrants, because I have warrants before.
Should not be on a warrant on these. Should have another warrant?
Not that I'm aware of, Your Honor. It would be my understanding that those warrants should have been lifted at the time she was arraigned, so.
Correct. Looks like you did have a warrant previously, at least on this one, and you were arraigned on the 19th. Yep, so the warrants were lifted then.
Okay.
Yep, so that's why it was set for these dates today to address it. And because they're written on citations, we don't do a nollie, which is a paper form to dismiss. I just write dismiss on the ticket. So you're all set.
Thank you.
You're welcome. Same to you. Okay, is that all? Do we have another criminal Mcferson here? Yes.
Yes.
On the record in the matter of the people of the city of Lansing versus Amari Mcferson, file number 23-01781. Council appearance.
Good afternoon, Your Honor. City of Lansing appears by Greg Bunker.
Assistant Public Defender John Lee appearing on behalf of Amari Mcferson.
How are you, Mr. Mcferson?
Good, and you?
I'm doing well, thank you. I think I reset this. You had provided proof that you enrolled in a GED class, and then we were going to address your issue of employment. You are or not employed?
Not.
You're not? And that was because you said you couldn't be employed? Or you didn't want to be employed?
Not that I don't want to, health condition.
Okay, so a health condition prevents you from being employed. I think this is the one that your probation officer had a concern about whether or not that was the case. I think there was a note, I don't see it in the file now, from your doctor that said that it's not clear as to whether or not you could not be, you were not employable, meaning you had some kind of disability.
Mr. Mcferson reports when he was younger, prior to the age of 18, that he was on Social Security disability. He is in the process of applying and has some doctor's appointments that were reset to early March to undergo testing for his heart condition, the results of which will either support his application or they won't. The anticipation is that they will.
What's it got to do with him working?
I'm sorry.
What does that have to do with me working? So you get a heart condition, you can't go to work?
Well, that was the question on the table was, were there some jobs that despite the heart condition that he could still do?
There's people who barely have working limbs and go to work. People that with all kinds of disabilities that work. And you're here before me because you're using substances you're not even legally authorized to use. If we're concerned about your heart, that's the concern, not getting a job. You can get a desk job. No one told you got to go here and till a land or plow something. Why do you not work?
Because there's no desk job that I found that you can work without a GED.
Why don't you have a GED?
I'm working on that right now.
So you're not employed because you didn't have the proper education, correct?
No, I can't get the kind of job that allow me to sit in a desk job with the credentials I have right now.
Oh, okay, so you can't do a job that requires you to stand.
Activities, standing, anything like that.
Okay, and that's for no periods of time you can stand?
I mean, it can call patients or I can have an asthma attack at any time. That's what I'm going to the doctors to get all these different tests for.
Well,
I've
then
been like this since
you
I was
definitely
born.
shouldn't be smoking marijuana and using alcohol then.
I don't even smoke like that. I eat edibles. It was either that or taking pills, and that just makes my condition worse.
And alcohol doesn't make your condition worse?
I haven't been drinking.
That's not what your
I got one.
probation officer says.
dirty-
That's why you're here.
One dirty drop.
Doesn't matter. Your probation officer says that your use has gone up. That's what she says. Based on your testing.
I got one dirty alcohol drop.
How old are you?
21
When did you turn 21?
in December.
Okay, so then you weren't legally able to drink alcohol at the time of the drop, correct?
I don't recall when the drop was.
November 20th was the time that we arranged you for a violation. Violation happened in November. You were 21, correct?
Yes,
And you had a heart condition,
yes.
and you didn't take that into consideration
Take that into consideration.
about how drinking alcohol could have an adverse effect on your health.
I do take it into consideration.
You did it that day though, correct?
Yes.
And
That's
you
how
took it and
I
you took it into consideration and you drank alcohol anyways?
That's how you interpret it.
No, that's not how I'm interpreting. I'm asking you a question.
I guess, yeah.
You guess you're what?
Yes,
You did take it into consideration or you didn't?
I did.
And then,
I always do. It's not
and
like I
then
don't
you
care
thought it
about
was
my
a good
health.
idea. That's not what I asked you. And you still thought it was a good idea to do that, correct?
No,
So why did you do it?
I mean, people go through stuff happens.
So you thought it was a bad idea when you did it?
Thinking about it, if it was a good idea or a bad idea.
So then you did not take it into consideration. That's the whole,
You
that's
said my health.
That's what taking
You
in consideration is. You
Well,
take
yes.
into consideration the impact. Well, I didn't think it was a good idea. Or I think it was not a good idea. Then you didn't consider it, is what I'm asking you. Did you think about it before you did it?
Yes,
What did you think about?
I wasn't thinking about my health in that moment. when
Well,
I
my
going
question
through
was, did you
something.
take into consideration how it would affect your health? That was the question I gave you. This is why you don't need to be using these substances, because it messes up your mind. There's research to back this. Your thinking is not that clear because you're using things that alter your thinking.
I got honors in both of my GED.
I don't care what you got. You don't got a GED, and I'm asking you very direct and clear questions, and you going back and forth. I asked you clearly. Did you take, don't go back, listen, you're not gonna win this one.
I'm not trying to win.
Okay,
I'm not trying to-
I'm gonna ask the question again. Did you take into consideration how these substances could affect your health before you consumed them?
No.
Thank you. That's what I want to hear, some accountability. I didn't take into consideration and I did it anyways. So for you to come before me and tell me that you can't get a job because you have some medical history, I'm not discounting that you have a medical issue and that you are probably prone to having, you said asthma attacks. I don't
Asthma
discount.
attacks,
I don't-
got heart disease too.
I'm not discounting that. What I'm saying is I need a documentation. And that was what I reset this for you to provide me evidence that you are disabled from working.
The social security office hasn't called back yet. My doctor's appointments got rescheduled, but there's nothing I can do.
Well, you're 21 years old. If you've been disabled from working, that should have been something already in your medical history.
I was never in a situation.
You never had to work?
No, I was never in a situation to have to worry about finances and stuff like that.
Until you became an adult?
No, until I started going through the situation. I lived at home with my mom.
I recognize that, but we told you as part of your probation requirements that you were going to have to work. That was an
I
order.
said I had a health condition.
I never said you had a health condition. I don't know anything about your health condition. I don't have your medical record before me. I said you was gonna have to provide, you were ordered to obtain or maintain employment, or you must provide proof of inability to work. Have you provided proof of inability to work?
I provided that letter the last time we was here.
What letter? The letter that said you couldn't work at that time?
That was just a couple weeks ago.
No, that's what I'm telling you is
I can get another
no, I don't need you to keep giving me a letter saying that this week he can't work. We need proof that you have a disability that prevents you from being employed. Because there's so many layers and levels of employment. There's so many things you could do. There's jobs that you can do from your house. And when I tell you that that's the majority where the jobs are going these days anyways. There's some that you can do. There's some.
I'm not saying I can't work at this job.
Right, and part of the reason why you were here is because you hadn't enrolled in the GED program either, so we had to, do you want to keep talking over me?
I got.
You want to keep talking over me?
No, ma'am.
Because I'm gonna remind you, probation is not your right. This is a privilege. And if you're gonna make this difficult and challenging, we can sever this. We can go ahead and remand you in the custody of the Ingham County Jail until the time comes for you to come back out, having served your time. Do you understand that?
Yeah.
I'm not gonna go back and forth with you. I'm not gonna wait for you to finish talking over me so I can say what I have to say. You need to provide proof within the next 30 days that you are unable to work indefinitely, or you're gonna provide proof of where you've applied for jobs every week within the next 30 days. Do you understand that?
Yes, ma'am.
March 18th at 1:15.
March 18th is your next court date at 1:30?
1:15.
At 1:15 is going to be your next court date. Again, you need to provide evidence in writing that you're disabled from being employed, or you're going to come with at least, I want to see at least 10 job applications. Because if you're sitting at home not doing much, you should have plenty of time to research jobs that don't require you to lift or exert yourself that you can apply to. You're going to have to tell me where they showed you you were unemployable. Okay? Do you have any questions?
Yeah, so do I have the proof of the GED or not?
Well, my records reflect you do have proof that you logged in or that you registered. It says from your probation officer.
Right now that I've been doing the classes?
You're gonna show proof to your probation officer. That's what she's here for. She told us
I
that.
didn't know that. She never said anything about that. I wasn't doing.
She said that you weren't, and then at our last court date, you provided proof. What I noted here that you had provided us proof that you were now enrolled. And so now her concern is your employment and the continued use of substances after reviewing your orders. That's what her concern was. When you leave here, you can go downstairs and check in with Ms. Duhosky, and then we'll see you in March.
All right, thank you.
You're welcome. Is Alexandria Berry present?
I have not seen Ms. Berry.
Okay, we'll issue a bench warrant, and then what about Martez Simmons?
Yes, Your Honor. So.
Martez Simmons?
Yes, ma'am.
Okay, I can't see your face.
Oh, I apologize.
Okay, what's on your head?
It's a hat because my hair isn't done. So you want me to take it off?
Yeah, you knew you was coming to court today. You could have got your hair all hooked up. Thank you. Okay. On the record in the matter of the people of the city of Lansing versus Martez Simmons, file number 23-02272 23L2793561. Council appearance.
Good afternoon, Your Honor. City of Lansing appears by Greg Venker.
Public Defender Godly on behalf of Martez Simmons.
Okay, today was the date and the time that was set for a pretrial for driving unlicensed and a speeding 1 to 5 over. How are we proceeding on these?
Right, Your Honor, Mr. Simmons reports that his road test with the Secretary of State has been scheduled for March 5th at 3:30 PM. He anticipates being able to obtain his license at that time.
Okay, we'll reset this pretrial for after that date. I thought he had a road test on January 11th. What happened with that road test?
I had
Okay.
caught COVID.
Oh, okay, sounds good.
What date?
It's March 5th.
March 18th at 10.
March 18th at 10.
Okay.
Do you have any questions?
No, ma'am.
Okay, any additional matters for the record?
Not for the city, thank you.
Nothing for the defense, Your Honor.
You're all set.
Thank you.
You're welcome. I have to write the note on, is that what it was? Telicia Martin?
I've not seen her, Your Honor.
Okay, what's your bench warrant? Is that all the city matters?
So,
Okay, thank you.
City matters are done.
That's it.
All righty. Thank you, Judge. Have a good day.
Have a good one. Okay, let's see. Someone here for Mr. Smith. Okay, on the record of LAFQ versus Gina Smith Kirkling, file number 17-02667. Council appearance.
Yes, good afternoon, Your Honor. My name is Joe Burnett, filling in for Tim Smith on behalf of LAFQ.
Thank you. Anyone present for Gina Smith Kirkling? Okay, our records do indicate that there was no service. Let's see. I don't know if this is an old note though. Let's see. We don't have that this was served.
Your Honor, I think that that would check out. I don't have this on our internal schedule for today, so I believe that makes sense. Sorry about that.
LAFQ versus Angelique Johnson, file number 22-0 1052 GC, council appearance.
Good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of Blackview.
Okay, and I do see Angelique Johnson present via Zoom. Ms. Johnson, do you have an attorney representing you at all?
I'm her daughter. I'm her power of attorney. She's right here also.
Okay.
Here you go.
What do you got now?
Okay, so today is a creditor's exam. I'm going to put you in a private meeting room so that you can answer some questions, okay?
Your Honor,
you've already spoke?
Yes, Your Honor.
Okay, did you need another date or were you all set?
We would like to request another date, Your Honor, a control date, just to give Ms. Johnson and her daughter some time to get some documents to us.
Okay. How much time?
I was thinking 30 days. We requested that she send Miss Sutton. Her name's Tisha Sutton. She's helping her mom. She said she would get us the last 6 months of bank statements, and some kind of verification of her mom receiving Social Security funds. And we didn't talk about this, but I would like to request that Miss Sutton send perhaps a copy of that power of attorney just for, verification and to put in the file.
I sent that to you guys already.
Oh, okay.
Your process server requested it before he would serve the paper. You guys told him to get it from me, so you should have it.
I see. I'll take another look.
Okay, I'll give you 30 days. March 18th at 2. March 18th at 2.
Thank you.
Is that 2 o'clock, Your Honor?
That's correct.
Perfect.
Do you have any questions, Ms. Sutton?
Oh, no, thank you.
Okay, any additional matters for the record, counsel?
That is all, Your Honor. Thank you very much.
Thank you, you're all set.
Thanks.
Okay, on the record in the matter of Gateway Financial versus Jessica Levy, file number 17-00957. Jessica Levy present?
Yes, good afternoon, Your Honor. Scott Schisler, P48832 on behalf of the plaintiff.
Anybody here for Jessica Levy? The date that was set for an objection that was filed, let's see. Objection to entry of order. She indicates that she had some financial issues that occurred, that she was paying faithfully and just couldn't afford the payment at the time and won't be able to have her wages garnished because she doesn't make enough and still be able to support her other bills and family. She can only pay $75 a month as agreed. This matter was scheduled for a hearing today at 2 p.m. It's 2:47. No one's appeared on behalf of Jessica Levy, alias Matthew Vandorp, is what the file states. She was ordered previously back on August 15, 2017 to pay a monthly payment of $75 for a balance. I think the balance that still only was for $2,003.18. Is that accurate?
That is correct.
Okay. It looks like she had not been making payments, and that's why the motion to set aside the installment payment order was filed. She's failed to appear to date and failed to comply with the installment payment order. And so let's see, the court will deny her objections.
Okay. Thank you, Your Honor.
Thank you. I believe there's a proposed order already in on base. I'll sign that order.
Okay, thank you.
Thank you. The record in the matter of credit acceptance versus Juan Navaro, file number 23-01064.
I'm here.
Council appearance.
Good afternoon, Your Honor. Now Jack Francis on behalf of plaintiff's attorney of record.
Okay, it looks like you all saw Judge Buchanan while I was possibly in the middle of a trial back on January 10th. And the note that she left was that this matter was adjourned to allow the defendant to make $100 payment. If payment was made, that we would continue the installment payments. If not, we would set aside the installment payments. So has those payments been made?
No, Your Honor, no payments have been made.
Mr. Navaro, you looked off as if you were surprised to hear that.
Yeah, because I made 2 payments and I made one today as well. I even called their attorney's office or something like that.
When did you make the payment prior to today? What was your payment date prior to today? What day did you make the payment?
The payment was made today.
No, you say you made 2 payments. What was the other payment made?
It was just one. Oh, I'm sorry. It was just one.
Oh, you thought that making the payment today would be sufficient when you were told January 10th that you needed to make a payment before today's date?
I thought I had a month to pay the.
Isn't it a monthly payment?
Judge, the requirement at the last hearing was that he was to remit at least $100 by January 12th.
I thought I had a month to pay that.
Why would you pay it before the day of the hearing? Why would you do that if you thought that? It doesn't make sense to me that you thought you had a month to payment, but you conveniently paid it the day of your court date.
I just got money today. They were under the. I told them that I wasn't even working at that time.
You got money,
I told
or
the judge.
The person whispering to you got money?
No, I had gotten money.
Do you work?
Yes, I worked third shift.
You work day shift, and so you
No,
knew you were
third
supposed to make
shift.
payment.
I worked third shift.
Third shift. Okay, and you, well, the judge's order was clearly that you were supposed to make a payment before today's date in order to have the installment payments continue, and you did not do that. We're already here because you had not been following the installment payment order. So she was trying to give you a last ditch chance to follow that order, and you didn't do it.
Well, I mean, I guess I didn't understand. I thought I had a month.
Did she say you had a month?
Judge, my notes show she stated it was to be made by 1/12. And Judge, I would also note we have not received a single payment on the payment order.
I have the receipt number that I have paid it.
She's talking about the payment or the installment payment order that you had in place before then, which was that you were supposed to make a payment of $110.42 per month.
Yes, and then we had that court hearing, and then I told them I wasn't able to pay 110, and I told them I wasn't able to pay 110. They still wanted me to pay 110, so then the judge let me pay 100, which I thought I was able to pay it within a month because I told him I wasn't working at that time.
I ordered you in August to make a payment of $110.10 beginning the 15th of the month. I don't know how it is that you can't pay $110, but you believe you can pay $100.
I wasn't working that whole time. I was a stay-at-home father. I just started working 2 weeks ago.
You made the agreement. You made that agreement. My note clearly says parties resolve matters. So you entered a private meeting room with the plaintiff's attorney and you came up with that amount.
I told them that I told them that I didn't have the funds, and yet they weren't taking, like, I don't know who I was talking to, the guy, but
So what is your suggestion? What do you think? That they should just not get their money?
I made a payment today. No, that's not what I'm thinking.
You were supposed to make a payment by the 12th. So you didn't follow the order.
I understand that now, but I was under the assumption that I had a month.
I don't know why you were under that assumption. I don't know why you got that assumption. The judge was very clear. Her note is very clear. Everybody except you was very clear. I don't even think you believe that. You first got on here and told me that you made 2 payments, and then the lady who's off to your side told you something else, and then you repeated something else. I don't even know that you're in charge here. You probably should be talking to the person who's hiding behind the camera.
I am in charge. That's my wife, and I had thought I made 2 payments, but I only made the one today.
Oh, you thought she told you that you only made one. I heard her when she told you that.
Yes, because I looked at her and then she told me that it was 1, and then I was like, "Oh, I'm sorry, it was 1."
You looked at her
I
more
first
than once.
said it was 2.
When
then
the
I
plaintiff's
corrected
attorney
myself.
said you had not made any payments, you looked right at you're the person that you said is your wife in awe because you didn't even know what was going
Because
on.
I
I don't
had
believe that you know
thought
what's
I had thought that I had made 2, and then I corrected myself after she told me, "No, we just paid the 1."
Okay, well, it's really not meaningful to continue a payment plan because you entered into a private meeting room where the court wasn't even involved. You, knowing your own financial situation, negotiated and came up with the amount that you would pay. And you stated on the court record that you would make that payment. And then you never made those payments. Now, when they want to set aside that agreement because you're unable to comply with it, you file a motion, you come before the court, another judge who was acting on my behalf tells you that you need to make a payment of at least $100 by the 12th of January. You don't make that payment either. You make a payment on the date of the hearing and believe that's supposed to satisfy the requirement. There's a reason why you had an agreement. There's a reason why you have a payment plan. You have a very large balance. You owe over $8,000. And they want their money, they have the right to get their money. And you've not given me any lawful reason whereby they shouldn't get their money. Therefore, I'm going to grant their motion to set aside the installment payment order.
That car that they sold me was completely and utterly trashed, and it was horrible, and they knew that.
I'm sorry to hear that, but you know what? At the time to collect on the payment is not where you get to dispute that. So you're served a summons and complaint. When that summons and complaint is served on you, that is the time for you to show up and dispute all the things that you believe was trash or fraudulent. You don't get to come after there's a judgment and then say that you have a reason why you shouldn't have to pay. You can't attack the judgment this way. That's not what the law allows you to do, okay?
That car is not even a fourth of what they're even asking for, and they're trying to say that it was damaged.
All right, any additional matters for the record?
No, Your Honor. You said the motion is granted?
I am setting a motion to set aside installment payment order is granted.
Thank you.
Thank you. All set on this matter. I think there was a proposed order on base. I'll sign it.
Thank you.
I'll file for bankruptcy. Do I get my money back then?
You talk to a bankruptcy attorney and they'll go before the bankruptcy court, okay?
Yep. So what's going on?
Judge, I have one more case.
What's your name, sir? Rahim. Okay. Let's see. Kesha Gonzalez is on Zoom. Let's see. On the record in the matter, of Rahim Alikanil versus Kesha Gonzalez, file number 23-02094 LT. Counsel, can I have your appearance?
Veronica Pereira on behalf of Ms. Gonzalez, Your Honor.
Thank you. And then I have Mr. Alikanil present in the court. Today was the date that was set for a hearing for, it says set for a motion. Nonetheless, I have a amended consent order for conditional dismissal. It states here, Ms. Gonzalez, that you are entering into an agreement whereby the matter would be dismissed today, and that you will pay the past due rent of $650 for court costs of $150 for a total of $800. That includes rent due through the time of February 29th, 2024, and that you, this amends the conditional dismissal from December 27th, and that the defendant will pay $200 by the 5th of February, that's today, 2024, $200 on or before the 10th of February, 2024, $200 on or before the February 17th, 24, and then $200 on or before February 24th, 2024. Is that a complete and accurate understanding of the agreement that you entered into, Ms. Gonzalez?
Yes, that's accurate.
Okay, Ms. Darconell, that's complete as your understanding as well?
Yes.
Okay, and so this is going to amend the previously admitted consent order for conditional dismissal. Again, partial performance will not satisfy this agreement. You have to perform fully and completely as you stated, making the payment amount of the dates that you said you'd make them. You understand that?
Yes, ma'am.
Do you have any questions for the court?
No, ma'am.
Okay, you're all set for today. Thank you.
Thank you, Your Honor.
Thank you. Sir, did you want a copy of that? Yes. Okay, we'll get you a copy. Okay, on the record in the matter of Cedar Place Apartments versus Timothy Stoyanski, file number 23-02859, counsel appearance.
Good afternoon, Judge Christopher Asphalt, 53129 on behalf of the plaintiff.
Thank you. What's your name, sir? Okay, Mr. Stoyanski, today was the date that was set for a motion to set aside judgment. You filed a motion to set aside judgments. Let's see, motion is filed within 3 business days of consent. You said new ledger was made by Cedar Place. It said also you didn't understand fully what Cedar Place lawyer was getting you involved in. And 3, to prove Cedar Place that the cost is wrong. So you're disputing the amount.
That's the waive those.
I'm sorry?
Waive my
You want to waive the motion? You meaning withdraw? Is that what you mean? Is that what you talked to him about? So you don't believe that there was an error anymore? Sir? I just need you to say it so the record can hear it.
No.
Okay, no objection to that?
No, Judge.
Okay, your motion is withdrawn. You're all set.
Does the court need me to submit an order? No.
Yes, please. You can submit an order.
Just that motion tonight for the reasons stated on the record. I'll submit it.
Thank you.
Thank you. Have a good day.
You too. Okay, on the record in the matter of Lake Trust Credit Union versus Latoya Hoskins, file number 23-02691 GC, counsel appearance.
Good afternoon again, Your Honor. Najat Francis on behalf of plaintiff's attorney of record.
Okay, and I see Latoya Hoskins present via Zoom. You can hear us, correct, ma'am?
Yes, ma'am. Can you hear me?
Yes, I can hear you. Okay, Ms. Hoskins, today was the date that was set for a pretrial. Did you all meet privately to do a joint pretrial statement, or did you come to a resolution on this?
No, I have not talked to them in over 7 years, Your Honor.
Okay, I do see that there was a jury demand that was filed in this. Let's see. Are you intending to represent yourself or hire an attorney, Ms. Hoskins?
For now, I'm just representing myself.
Okay, so what I'll do is I'll put the parties in a private meeting room so you can complete your joint pretrial statement or talk about potential resolution, okay?
Okay, thank you.
No problem,
Thank you, Judge.
no problem. Let me see. Mr. Visconti. Which matter are you here for?
Your Honor, I have Philip C. Dean Apartments, Mary Avenue, LDH, ADB, Philip C. Dean Apartments versus Yvette Ross.
I don't have any more files. Oh, that Ross. I don't have that file. I'm missing some files. Let me see here. I was missing the Hoskins file. That's what I'm missing. Okay, I don't see that Ross present in the courtroom. Let's make sure she's not in the hallway. Okay, Mr. Visconti, no one's appeared. Did you want to default?
Yes, Your Honor, I do.
Okay, default judgment will be entered. Can you file that through on base, please?
Yes, Your Honor, I can.
Thank you.
Thank you. Have a good day.
You too. Okay, Ms. Francis, did you all come to a resolution on the joint pretrial statement?
We did, Your Honor. We reached a agreement for a consent judgment.
Okay, let me go on the record. Okay, on the record in the matter of Lake Trust Credit Union versus Latoya Hoskins, file number 23-02691 GC. Can I have your appearance for the record, counsel?
Najat Francis, P72322 on behalf of plaintiff's attorney of record.
Okay, and then I have Ms. Hoskins present without counsel. Today was the date set for pre-trial for a general civil matter. Each of the parties have come to resolution.
We have, Your Honor.
Okay, can you place the consent judgment?
Yes, Your Honor. We have agreed to a consent judgment. The damages are $3,336.56 plus the cost and statutory attorney fee for a total of $3,561.17. And defendant will pay $100 per month beginning March 1st and by the 1st of each month thereafter. And Ms. Hoskins is giving plaintiff permission to sign the consent judgment to e-file it with the court.
Hoskins, is that correct?
Yes, ma'am.
Okay, so you're entering a judgment by consent, whereas you agree judgment to enter against you for a total, including court costs and filing fee of $3,561.17, and that you will make installment payments of $100 per month beginning March 1st. Is that correct?
Yes, ma'am.
Okay. Do you have any questions about that?
No, ma'am.
Okay, you understand that you have the right to proceed to a trial in this matter?
Yes, ma'am, I do.
You also have the right to be represented by an attorney in this matter. You understand that?
Yes, ma'am.
And you want to give up each of those rights to have judgment enter against you by your consent?
Yes, ma'am.
Anybody threatening you to get you to do that?
No, ma'am.
Has there been any promises made to you in exchange for you entering into this consent judgment?
No, ma'am.
Okay, you have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you just waived, you can return to the court. You can request to file a motion to set aside the judgment. We'll set the matter for a hearing, okay?
Okay, thank you.
You're welcome. Did you give the attorney permission to sign the consent judgment on your behalf?
I did, yes.
Okay, and I'm going to say this again. I do recognize you're a bit emotional now, but the issue is we get a lot of people that either don't appear in their civil matters or they appear and they enter into agreement, and then once they can't make the payment on the installment order, then they later want to attack the judgment. You can't do that after the fact. If you have an issue or you disbelieve this to be an accurate judgment, you have to attack it as a judge before it becomes a judgment. You can't waive those rights, and then once you can't make the payment, now all of a sudden you have all these statements that you want to make about the validity of the accusations against you. You understand that?
Yes, ma'am, I understand.
And do you have any questions at this time?
No, ma'am.
Okay, and then Ms. Francis, you're gonna file that on base?
Yes, Your Honor.
Okay, any additional matters for the record, counsel?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you.